My name is Anthony Valluzzo, and I'm an attorney here in Sonoma. I have my practice down the street from Vintage House. I practice with Haeuser, Valluzzo, and Piasta. My partner is Tom Haeuser, who's been around since the 70s, and Mary Piasta, who has her business with us as well. We focus primarily in estate planning, preparation for the inevitable, as well as everything that goes with it. We do a lot of business with mom and pop businesses that want to pass down their to the next generation everything and make sure their legacy continues, as well as just helping iron out things after people pass away, whether it's probate, trust administration, or the like. Um, let's see, a little bit about me. I came to the Valley in 2010 from the Bay Area. I was immediately before this, I was actually in public accounting at PricewaterhouseCoopers. And before that, I was in law school at Santa Clara. Um, Before that, I got my master's at the London School of Economics, and I did my undergrad at Seattle University. So I'm a Seattle transplant. Came south for the sun, and except for fire season, it's been great. Um, and I have my wife Mary, who I
I'm
practice.
losing your sound, Tony. I can't hear you.
You guys can't hear me? Okay. Is that better?
No.
We
No?
hear you.
We hear you.
You do?
Yes.
I can hear you.
We hear you too.
Your sound's good.
Okay. All right.
Must be my system.
Yes. Sure.
Okay. Well, if you have a problem, feel free to speak up. I want to make sure everybody gets what they need to out of this. So this today is going to be a presentation based on the movie that I think a lot of people have seen and are very concerned with, called I Care a Lot. It's a movie that came out, I think, the end of last year on Netflix. I don't know if it came out anywhere else, but Netflix is definitely where you can find it. What I'm going to do right now is screen share so you can see my slide presentation, and then I'll be talking over it as we go here. So bear with me one moment. Okay. Can everyone see that?
Yes.
Okay, great.
Yes.
So the movie that I'm referring to, I think a lot of people have seen it. It stars, let's see here. It stars Rosamund Pike, who is standing there. She is the guardian or caregiver in front of a wall of pictures of the people that she takes care of. And if you haven't seen the movie, you can see just by that picture that these people are all elderly. And I think that's why a lot of people really connect with the movie and are nervous about it. The Peter Dinklage is in it. Diane Weist is in it. It's actually a pretty good movie. Takes place in Boston. It's very important that first off the bat, everyone understands that this is not a California state. California is very, very different. We really take extreme means in protecting the elderly, not only in just situations like this, but also California is one of the first to enact elder financial abuse statutes that typically can be looked over. A lot of states tend to be concerned about elder physical abuse, but elder financial abuse, especially with all the phone calls and emails that I think a lot of people get asking for money, trying to swindle people. California has laws in place, and so I'll be going through very quickly what happens in the movie, and then kind of comparing it to California. In the movie, a woman, I believe it starts with a woman who is in her home, and she is told that this woman, Rosamund Pike's character, is now her new legal guardian. And the reason that happens, we find out, is that she went and saw a doctor who assessed her, and I got the impression it was not her typical doctor, assessed her, thought she had the beginnings of whether it's dementia or Alzheimer's or some sort of similar condition, declared it an emergency, and then the doctor and the guardian, as she's called, went into court and got an emergency order. And so the guardian got control of the elder. She was able to put her in a home, as well as control of all of her assets. And the elder was not in court. The elder was not represented. It was all a very seemingly fast process. So if there's anything you should take away from this, it's that California has a much more detailed, extensive program than that. In California, we call the process conservatorships. The guardianship title is reserved for issues with minors. So we're going to be talking about conservatorships in California. That's the equivalent of the guardianship that was in the movie. One of the things that California is great at is that it doesn't like to use the court system. It would rather people figure this stuff out and be taken care of by family, by friends, by private means, rather than get the state involved. However, if necessary, the state will get involved to protect those people who may not have relatives, friends, and resources. So jumping in, California has a few different types of conservatorships. They have a limited versus a general. This is something that the courts like to see, is they like to see if there's going to be a conservatorship, it needs to be the least invasive possible. The temporary is like the emergency order that was that the judge gave in the movie. In California, the temporary is the emergency, and it's a maximum of 60 days. It usually probably around 30, and at some point that's done just to take care of the senior, of the elderly person, and other plans have to be in place, whether it's a long-term conservatorship or maybe just getting some family that's out of state kind of up and running if they didn't know about the situation, things like that. It's great because you don't automatically get told by the court that this is your conservator and they're going to completely take care of everything. Everything's out of your hands. It's not like that at all, which is fantastic because independence is still a priority. Living in the home is still going to be a priority if that's what the conservatee or the elderly person wants. And I'm going to touch on that a little bit more later, but I just want to get that idea across that the emergency orders are very, very limited. And as you can see from the slide, this is a picture, for those of you who haven't seen the movie, this is a picture of the conservatee who, quite frankly, is, I don't know if they said her age, but she's very young. She might be having just a touch of memory issues, but it's a very strange situation. Of course, it's a movie, but again, this is not California. So some of the things they can't do in a temporary conservatorship is move the conservatee from their home, and that includes even putting them in someone else's home. It might be okay as long as the conservatee is in agreement or they state that preference, but it's not mandatory, and their preference really will be listened to first and foremost. So as a result, you're not going to be able to have your home sold out from under you, or those who are renting, a rental agreement can't be ended. It's the sort of thing where it's kind of considered just like a maybe extended hospital visit or vacation even. And then the selling or giving away of conservatees' assets. That's extremely important because even people with estate plans may have a list of assets that they want to convey to various people, whether it's children, grandchildren, friends, what have you. And the idea is that after you pass, then it gets distributed. Selling or giving away any of it before that happens is not going to be something that needs to be worried about. It's not going to be something that, even if money is an issue, there's going to be an extensive amount of input that's going to be based on what the conservatee wants. And a lot of that is going to depend on how responsive the conservatee is. But the court really likes to take care of its seniors, and so that is going to be something that it definitely makes sure it takes into account, is how the conservatee feels. So one of the requirements, or I guess just going through most of the primary requirements for California's conservatorships, that is good, and are a little different probably from what was in the movie, is that relatives must be given notice. It's very rare, and the petition is very strict on stating whether or not, if the conservatee has children, they must be notified unless they passed away. But if they passed away, the court wants to know that happened. If the conservatee doesn't have any children, then it's going to be siblings. If the conservatee has parents alive, it's going to be parents. If the conservatee doesn't have siblings, doesn't have parents, doesn't have children, then they're going to want to know who is the next related person, whether it's cousins, what have you. And they're required to be given notice that this is happening. So whether they're in another state or California, it doesn't matter. California requires relatives to be given notice. A court investigator. This alone probably would have helped the conservatee in the movie. A court investigator is appointed by the court, and their job is to take upon themselves interviewing the conservatee, participating or reviewing, doing a background check on the conservator or proposed conservator. They want to know the relationship. It's very important. So not only could the court investigator be curious as to why a relative isn't being proposed as a conservator, but the court investigator will try and determine whether or not, if it's a completely unrelated person, there's any sort of debt or any sort of loan that the elderly person has that they owe to the proposed conservator. That's another situation where the court really wants to get involved and understand it. That doesn't obviously happen very often, but if it does, the court wants to be aware of it. So the investigator really looks at not just what the conservatee wants and the background of the conservator, but ancillary issues that may come up and may become an issue later on. The third one on the slide is that the conservatee must be at the hearing. We saw in the movie that the conservatee was not at the hearing, and the doctor said that it was because either it was an emergency or she just wasn't able to be there. The court needs a good reason, and the court typically, if there's an illness, wants a note from the doctor. If the conservatee is just not there. Now, bear in mind, often this is the sort of thing where the court really wants to see the conservatee. So people can be, who aren't normally in a wheelchair, for example, maybe wheeled in and not completely aware that this proceeding is going on, but they know what they want. And that's what the court really wants to see when they bring someone in. And they also want to see that the conservatee is limited and therefore the conservatorship is warranted. But the court is very serious about having the conservatee at the hearing. If it's a temporary and they aren't at the hearing, then the court will require them to be at the general or limited conservatorship hearing. So there are going to be multiple times when the court will ask, and they will be willing to push things back and not grant the conservatorship if they don't see the conservatee, if they aren't able to talk with them and understand and see for the judge itself what really the situation is. So then we get into choice of conservators. The court's preference in California makes a lot of sense, and I think will help set people at ease, because they want to see first that the spouse or partner doesn't want, essentially, or cannot be the conservator. After that, they look at the adult children, and they look at the parents, and then the siblings, and then any other person allowed by law. The guardian in the movie, she would be a professional. So in California, we refer to them as professional fiduciaries who are trained and have a license to take care of individuals in a way that benefits them. They have to obviously pass a background check and help in a more hands-on way than attorneys. So my guess is that the guardian was an other person allowed by law. So if you think of it in those terms, this means that the person who was the conservatee didn't have a spouse or a partner, didn't have a child, didn't have a parent, and didn't have siblings. And so that's why it fell to the guardian. It's going to be rare. It's going to be absolutely rare. And California will do everything it can to prevent that from happening. The other thing that needs to happen in California is that accountings must be given. So a lot of the times, conservatorships will be sought so that people can take care of an elderly parent or aunt or uncle. And maybe it's purely for financial purposes. They're perfectly able to take care of themselves physically, prepare their meals and whatnot. But financially, it's just getting a little bit too much. So what the court says is it must have, first in the petition, it must have an idea of what sort of assets are there, first off. After that, and if the conservatorship is granted, then within the first year, an accounting must be filed. And this accounting starts with all assets as of the date the conservatorship begins, as of the court's order assigning the conservatorship, to the end of that period for the next year. And it all has to pass muster. So the interesting thing is that not only is the accounting filed with the court, all of the statements have to be filed. Bank statements, brokerage statements, each and every receipt, if possible, needs to be filed. The more information you can provide, the better. But if the court doesn't get those bank statements, and these need to be from the bank, not copies, but actual originals, then they will ask the conservator to appear to answer questions. So once that's completed, then the accounting is still due every 2 years thereafter. So it's even once the conservatorship is granted, it's still quite a lot of work on behalf of the conservator to continue to operate things as they see fit. Okay, so as I mentioned this already, but the petition itself is one of the required forms and needs to detail the conservatee's difficulties, as well as their assets, who the relatives are, their contact information, and why the conservatorship is necessary. In that reasoning, they want to see that the option of not having a conservatorship was considered. And for various reasons, that wasn't something that was possible in the scenario before the court. The other forms are the notice of hearing, and that notice lists all the people, including the relatives, who are going to receive a copy of the petition. Confidential supplemental information. This is one of the things that the court investigator is going to be looking at. This could be something as simple as stating the conservatee hasn't talked to a son or daughter, for example, for 10, 20 years, and wants to get back in contact with them. So if that's possible, please allow that. Or it could be along the lines of they've been taken advantage by a son or daughter, and this person is no longer in their life, but it's something to be aware of. It could be also information on essentially anything that would help the court. And it's always good to provide too much information rather than not enough. A lot of it may be health related as well. Duties, the handbook of the duties of a conservator, that's a big one. The state puts out a handbook that's free and requires the conservator to say that they've read it, they've received it, and they will abide by it. I don't know of any other states, to be honest, that produce a handbook for the conservators. It's something that is, for all intents and purposes, a little bit basic knowledge, a little bit common knowledge, but does have those dates of when things are required for the court, whether it's accountings, interviews, and that sort of thing. The screening form for the conservator, this is a background check. This is very much a background check. So the police records and things of that nature are going to come to light, and they need to be explained to the investigator. The capacity declaration is usually going to be from a doctor, and oftentimes if there's a little bit of a pushback, whether it's from the conservatee or someone close to the conservatee, then it's a good idea to have two declarations from two different doctors. And the dates need to be relatively soon, or not before the hearing, obviously, but they need to be within the last few months of when the petition is filed and the hearing is going to be held. They don't want to see that it's been over a year and the doctor hasn't been able to update it, or things could have changed. Things could have changed for the better. There's a lot of medication out there that people can be on that can decrease their capacity that is completely temporary. So the court wants an explanation of what that capacity is due to, as well as whether or not it's temporary, how long ago the conservatee was examined. The letters of conservatorship and the order are going to be tools of the conservator to, if possible, open new bank accounts, to present to brokerage houses or even business partners to explain that they are going to be taking over, at least for a little while, or at least on a limited basis, for the conservatee. Those are provided once the hearing's been completed and the court has signed off on the conservatorship. So some of the alternatives to conservatorships are ones that I think, naturally consider, but we don't necessarily understand how that can play out in the context of the legal system. For those with children, sometimes we make informal arrangements to stay in their home and have a son or daughter visit, maybe on a daily basis, maybe on a weekly basis, some sort of routine. Or if they get to the point where they can't take care of themselves in their home, they'll move in with one of the kids. I think that especially with COVID, and things are getting back to normal, but especially with COVID, that was not as much of an option. So that really put a wrinkle in a lot of the informal arrangements that people were making. What's more is if you have more than one child, often there's one that is clearly someone you're going to live with or is going to take care of you. But as we all know, that can change, whether due to health issues, divorce, relocation. It's not always as stable as we imagine. And again, if this is the sort of thing that you create informally, then just a handshake agreement with your kids saying, I'm going to be staying at home and you'll get me, let's say, a caregiver, it may not go that way. And so the children may be able to say, well, we feel more comfortable with you being in a home against your will. And if that's just something we obviously don't want to run up against if we can help it. And it's not, that handshake agreement is not enforceable. People can change their minds, and sometimes for good reasons, sometimes just for not so good reasons. So it helps to have an idea and something in place. Now, one of the best alternatives, obviously, is an estate plan. I think when we talk about estate plans, a lot of people understand about wills and even trusts. But here's where the lesser known documents that we can prepare come into play. Springing power of attorney is one that really should be put into place, because it's springing because it doesn't take effect until you actually have been declared your capacity is at issue. So going back to what we've discussed so far, if financially you're finding it hard to keep up with bills, and not because of your finances per se, but more because of just remembering to write checks, that sort of thing, that may necessitate that springing power of attorney. The benefit of that is that doesn't happen until you're actually deemed unable to take care of that aspect of your life. So a doctor needs to get involved. No one can just go to a bank and take your assets as they did in the movie. It's all dependent upon you being declared not incapacitated, but limited in that regard. Powers of attorney don't have to be springing. you can assign someone that you trust a power of attorney, and they can, when needed, step in. I have a dear aunt that passed away that I was her power of attorney, and she asked me occasionally to step in when she didn't want to manage things, and I did, but we had the understanding that I would be in the background. So that was a benefit. And a lot of people, I think, especially when it comes to finances and bank accounts, will put someone else, whether it's a child or even a caregiver, which I don't think is ever a good idea, but someone else on the account. So in hopes of avoiding probate and making things easier so they can sign checks. Remember that once you put someone on your account, if you do it, there's always the risk that that person can take advantage of it, that they can do things without your knowledge. And I'm very aware of the importance of keeping one's autonomy and control for as long as possible. So what I recommend is you execute a power of attorney, and you just keep it. You don't even have to tell your agent that it's there. It's there. It's somewhere where you can just say when the time comes. So your agent should have this, and they can use that to help you out with the banks, brokerage houses, and what have you. Healthcare directive. We have a healthcare directive term or paragraph that is detailed there, stating that primary residence is where the person who signs it wants to live for as long as possible. A lot of the time, this is something that is assumed. It's something that a lot of people think, well, I've talked with my kids, I've made it very clear that this is what I want, and of course it's going to happen. Well, with the healthcare directive, what happens is your wishes as best as can be stated are in that document, so that when the agent that you pick steps in, it's for two reasons really. One, they are not questioning what your wishes are. So especially if they're a child or a spouse or a partner, they don't have to make a decision that emotionally they may not be ready to make. But also to remind them what it is that you want. And if your agent wants to do something different, the healthcare directive is right there to say, no, this is what you said you wanted. Now, can you change your mind later? Of course. But the terms like this paragraph, they are reflective of your wishes when you execute the document. And of course that can change, but in case it doesn't, you have that assurance in the document itself. So just before we wrap up and I open it to questions, I want to be helpful in that the California Courts website has a lot of self-help for seniors. In fact, they have literally a self-help for seniors page. It's great to review, and it speaks very simply of some of these complex processes. Another resource that is very helpful is Senior Advocacy Services. They actually provide a service that California has, which I don't know about Massachusetts, but is a very good service. It's the Ombudsman Service. And what happens is California has a law saying that if you are going to execute an estate plan document, so a healthcare directive, a power of attorney, a will, or a trust, while you are a resident, whether temporary or permanently, of a home, the ombudsman needs to be notified so that they can witness and talk with you to make sure you understand what's being signed and make sure the document says what it needs to. If that doesn't happen, then the executed estate planning document can be overturned and thrown out. So, and not a lot of people really know that or understand it. It's a very important service that Senior Advocacy Services provides in that respect. And then, of course, Council on Aging, which is located in Santa Rosa, but helps people who don't know where to turn or find themselves in a little bit of whether it's trouble financially because they are not getting along with children or caregivers or what have you. Council on Aging is a great resource in that respect. So I will take my camera off screen share so you can see me. And I will open up the floor to questions. I have the chat open, so please feel free to either send a chat or unmute yourself to ask, or however I think Vintage House wants to do this. So
I have a question.
yes.
What's the difference between an executor and a conservator, and are both always in living trusts or wills, or are they separate forms?
Good question. So an executor is strictly for a will, and I'm sorry, what was the executor and then?
And conservator.
Conservator. Conservator is for conservatorships. So if you have a will, you're going to have an executor.
Right.
If there's a conservatorship, then the person who's going to be taking care of the other person is the conservator. The conservatee is the person being taken care of. So those terms are different in that way. Now, to back up a little bit, a living will is typically actually a healthcare directive, because a living will, I think a lot of people refer to it as what they want to have happen in case they're not able to express it. So in that case, it's going to be your agent for a healthcare directive. And these are really good questions because the terms are just so different. And for a power of attorney, it's going to be agent. You're going to be picking your agent. In different states, that's going to be called different things. Mm-hmm. I think in New York, it's called a proxy, a healthcare proxy. Other states can be different, but the conservator is going to be for conservatorships, and the executor is going to be for a will.
So in terms of making it easy for, somebody who's aging and, wants to make sure that their assets are protected, it sounds like we have to have an executor in a will and a conservator in a, do they ever butt heads? Is your conservator and your executor, can they sort of argue where things need to go and how do you differentiate all of that?
Right. Yeah, they can definitely butt heads, but the interesting thing is that with the conservatorship, the conservator to have any sort of authority has to be approved by the court. So if they don't have that, they're not a conservator. They're just essentially a caregiver.
Okay.
An executor, even though they may be named in a will that's validly executed, that doesn't matter until the person dies. So for them to butt heads, it's kind of, I apologize if this is getting a little dark, but the executor steps into their role when the person dies. The conservator is there when the person is still alive.
Okay. So you should have two separate documents that are sort of well prepared for either one of those events to happen.
Right. And so without specifically talking to your situation, I'm just talking in general, right? This is not privileged information and not something that you should rely on. But in general, the role of the executor can be the same person that you would have you would give to somebody who's your conservator. For
Okay.
example, couples who have one child and who's an adult child,
Mhm.
they're typically going to have that person, and it doesn't have to be this way, but they're going to have that child be their agent for their power of attorney, their agent for their healthcare directive, their
Okay.
executor, and then if they have a trust, their trustee.
Okay.
That's fine. That's keep in mind that's a big load.
Yeah.
You don't get the potential conflict that I think sounds like you're trying to avoid that way.
Yeah, mostly just, I mean, if we had a list prepared of what forms we should actually have, readily and available, filed away. Here's my power of attorney. Here's my healthcare directive. Here's my executor. Here's my conservator. I mean, you hate to have to think to do it that way, but in order for it to make it things go quickly and not get, stuck in courts and things of that nature, it would be nice to know exactly which forms we should have prepared. That's all.
Right.
Yeah.
For conservatorships, if you have a healthcare directive and you have a power of attorney,
Uh-huh.
then it would be rare that a conservatorship would be needed.
Okay, great. That's very helpful. Okay, thank you.
Any other questions?
I saw one pop up under chat, I think.
Oh, really?
Thought I saw it. Oh, no. Yes, her question was, wait, hi, a power of attorney for healthcare and finances equals a voluntary conservatorship? I don't know what that means. Oh, well.
Was it just to you, Wanda May?
No, I don't know, maybe they got caught up in, yeah, she might, it's Lori Merrill.
Oh, that's Lori Beth. Lori Beth is she's a professional fiduciary, and she works with us, and she's often catching me and reminding me of things. Yeah, I think what she was getting at was that the safety net of a conservatorship is something that can be essentially recreated with that power of attorney and that healthcare directive. But just like a trust will help avoid probate for your assets, the power of attorney and the healthcare directive will help avoid the court getting involved through a conservatorship.
Mhm.
So, when we talk about estate planning, a lot of the times we think, okay, well, we just want to direct where things go to who we want, and maybe we want to not have that lasting, I guess, kind of experience in the hospital.
Mhm.
But a lot of the times, these estate plans help with more than that. Obviously, the court system is overloaded. Even now, especially now with COVID, they are really working towards getting through some of the backlog due to the court being shut down. And so things get pushed out a little bit further. They're also more costly.
Mhm.
And it's just a heck of a lot easier to avoid conservatorships and probate and anything with the courts if you can.
What's your take on long-term care and how important it is? And if you have it, and you have to get it, I guess, before 70 or 75, I can't remember, but.
Yeah, long-term care is great. Of course, it's unfortunately expensive, often very expensive. I think even for people who are hopefully decades away from needing it, but it does help. One of the most expensive aspects of growing old is having a caregiver, needing somebody who can help you out. And Some people may not need that, may not want that. Some people may rely on a child or even cohabitate with a friend, so that the two of you could work something out.
Mhm.
But long-term care really takes the guesswork out of that. I think it really depends on your situation, financial, as well as your health. If it's the sort of thing where your mobility is limited already, then maybe a caregiver would be pretty obviously in your future, and so therefore the long-term care would be a good idea. But it really all depends. A lot of caregivers are not, they're just purely people that want to help take care of the elderly and aren't necessarily licensed, don't have any other qualifications than they took care of one of their parents, and so this is now something they do. So
And
it helps.
go ahead, sorry. The
Oh, no.
long-term care, if you have long-term care, does that fall under the directive of a conservator, or like, in other words, basically it's a product and it's in your file, right? And if something happens to you physically and you need or want long-term care, who handles all of that? Is it your conservator, or is it your executor, or your healthcare directive, or?
I think the person who would probably be directing that, I think, first of all, you'd work with your long-term care provider,
Mhm.
and they would help you in that regard. And typically they have names and resources of people you can turn to for help with that. If you're in a conservatorship, that might be a reason, to be honest, to dissolve the conservatorship, because you will have long-term care. You will have somebody who will be able to take care of you. But if you have the conservatorship, it would be the conservator. If you don't have it, then it would be your agent for your power of attorney, because they would be addressing the financial aspect of it. And then if your agent for healthcare is different, and they had to get involved, then they would be pulled in as well. But typically the healthcare agent doesn't get pulled in until something really needs to be decided, whether it's something like hospice or pulling the proverbial plug, that sort of thing. So mostly your agent for your power of attorney.
One last question. Can you have just one person that can be all three of those or four of those?
You can't.
You can't. So you can pick, John Doe, your nephew or whatever, who you trust implicably to carry out all of your wishes as you age and where you want to be and what you want to do, where you want to put your money and things of that nature. So, so you don't have to change it up. It doesn't have to be different people.
Right. And what we do is, I think it's pretty standard operating procedure. We put, especially if it's one person for everything, then we give you or put in the documents the second choice. So that may be different for an executor, power of attorney, healthcare directive, and then even a third choice. Mm-hmm. So what can happen is someone can just get, I've seen parents who have a 22 to 25-year-old daughter, not married, out of the house, but no real roots. She's everything. That's a lot. That's a big burden put on her. She might get overwhelmed, and so we put in two other options for everything, in case she couldn't do it or didn't want to do it or what have you. So always remember that these people that you're naming can choose what they want to do. If they're named in those documents you create. If they decide they don't want to do it, they can, in fact, refuse to serve, which just means you go to the next person on the list. Mm-hmm. And That might just be a personal choice. That might be have a good reason, what have you. But that's why we have more than one person.
Right, okay.
Any other questions?
All right.
Okay. Well, thank you very much for your time and spending the little bit of your morning with me. Yeah.
Thank you,
Yeah,
very
thank
helpful.
you.
Actually, I
Yeah.
do have one question, Anthony.
Sure.
Oh, okay.
Which portion of all of this would someone come to you for?
We would be happy to help with an estate plan. So the best way to, I guess, to address this is to prepare. Just in case. That's kind of the motto around here. So we would help to avoid the conservatorship, as I mentioned, prepare that power of attorney, prepare that healthcare directive. On the off chance that someone needs a conservatorship, we can help with that as well. And we can also help with different aspects of a conservatorship and even advise people on whether or not one is needed if they feel like it might be a good idea. So essentially, we just encourage people to call and ask questions. We're happy to talk. It's an area of law that is going to be more important, I think, as the population grows older. The boomers and the silver tsunami we keep hearing about comes. So knowledge is king, and I very much believe in that.
Is it a questionnaire that you provide, that nice lady just asked, in order to obtain your services, for instance? Do you provide a questionnaire, and that's what we help?
I'm a little old-fashioned in that I don't, but I would be happy to sit down with anybody for a complimentary half hour to discuss, whether it's on the phone or Zoom or whatever someone's comfortable with, to discuss their situation and what they might need.
Okay.
Can you put your contact